Hello, Chair and members of the committee. I'm here to present AB 2282. Many parents in the family regulation system have suffered from the mass incarceration trend. The statistics show that 11.4 African American children and 3.5% of Hispanic children have an incarcerated parent. It is not uncommon for parents in dependency court to have a conviction for offenses defined as a violent felony. While the majority of states bar reunification efforts to parents with convictions related to the harm of a child, California law provides no exception for those convictions unrelated to any harm to a child. California presents the most rigid barrier to reunification with the broadest list of applicable convictions and no requirements that a risk to a child's safety be shown. AB 2282 would limit criminal convictions used to deny reunification services to families in the family regulation system. It would amend the law to deny services only to the most serious and violent felons who have endangered children. This reflects the safeguards taken by almost every other state regarding reunification for a parent with a violent criminal history, preserving the safety of the child and the family unit. Here with me today is Julia Hannigan with Dependents Legal Service and Fidel Chagoya. Thank you.
You may begin. 2 minutes each, please.
Thank you. Honorable Chair and committee members, thank you for your time. My name is Julia Hannigan, and I am the Policy Director at Dependency Legal Services. We represent parents and children in child welfare proceedings in Northern California. We are proud to support amending the felony bypass statute to encompass only violent felonies that involve a child. In terms of child welfare, the termination of parental rights is often described in case law as the death sentence for parents in dependency court. In that context, the bypass statutes often mandate that parents are swiftly sent to this death sentence without the opportunity to prove that they can create a safe home for their children. It means families are immediately put in the position to be permanently separated. This bill limits the families that will be forced into that predicament. It focuses on bypassing the parents who have convictions that involved a child. This change would put California more in line with what much of the country already does. We believe narrowing that focus makes sense in the child welfare system, which should only be focused about the risk of harm to the child. We do want to be clear, this bill does not mandate return to parents who still remain a danger to their children, nor does it require immediate placement with parents with these serious convictions. Instead, it requires the court to give parents the opportunity to show that they can make a safe home for their families. We believe that this change benefits both our minor and our parent clients. It gives our child clients the full and fair opportunity to grow up at home with their parents, if it is safe to do so. It also allows our parent clients the chance to make changes in their lives and become the parents that their children deserve. We respectfully ask for your aye vote.
Good afternoon, Honorable Chair and members. My name is Fidel Chagoy, and I currently work at Starting Over Inc. as an organizer for Riverside All of Us or None. Starting Over Inc. is a nonprofit that helps formerly incarcerated people navigate and obtain housing, employment, and getting the records expunged. I have a certificate of rehabilitation and currently finishing up my master's program in clinical mental health counseling at the University of Redlands. I am speaking to you today because I am a formerly incarcerated parent who lost my rights as a parent. My first and only daughter, Zoe, was born in 2016 when I was 39 years old. At that time, I had been out of prison for 6 years and off parole for 4 years and had managed to find steady work, housing, and transportation. During childbirth, Zoe's mother tested positive for opiates because of Tylenol with codeine that was prescribed by a dentist and having previously lost parental rights to her other children. This triggered the involvement of San Bernardino County's Children and Family Services, who looked at my past criminal record and said I should not have an opportunity to even reunify with my child due to Welfare Institution Code Section 361.5B12, the bypass provision. My parental rights were terminated, and in 2019, Zoe was adopted out with 119 other children in San Bernardino County, even though my prior criminal history had no bearing on whether I would be a good parent or not. If this change in law proposed by AB 2282 existed at that time of my case, I would have had a fair chance of reunifying with my daughter. I am here for you to consider making sure that many parents like me who have felonies unrelated to their ability to be a parent and in many cases have paid their debt to society a fair chance of getting their children back. For these reasons, I express my support for AB 2282. Thank you, Chair and members.
Thank you. Do we have any additional support in the room from the public?
Yes, Kevin Asner, Coalition California Welfare Rights Organization. Strong support, family values. Thank you.
Madam Chair and members, Adam Keglin on behalf of the Anti-Recidivism Coalition in support.
Sam Wilkinson on behalf of Grace and End Child Poverty in California in strong support.
Dave Schuster on behalf of Dependency Advocacy Center in strong support.
Christina Curtis with the Los Angeles Dependency Lawyers, proud co-sponsors and in strong support.
Hi, Christopher Hernandez with California Connection in support.
Thank you. Do we have any primary opposition to this bill? Seeing none, is there any public opposition to this bill in the room? Seeing none, I'll bring it back to the committee.
Move the bill. Second.
Thank you. Assemblyman Asali.
If I understand, first of all, I appreciate the author. I know you're sincere in your intentions. I guess the concern I have here is existing law provides discretion to the court to already allow unification on a case-by-case basis. So the court can look at the circumstances of the particular case and see if it's appropriate to allow reunification. And these are cases which a person has been convicted of a serious felony. We're talking about murder, we're talking about rape, we're talking about robbery. And so I understand this would basically require the judge to order reunification unless the violent crime was committed against a minor. And so I'm just worried that even if you didn't commit the crime specifically against the minor, let's say you raped an 18-year-old instead of a 17-year-old, I'm worried that this is going to create a situation where children are going to be placed in situations with individuals who may not be safe for them. So I guess my question is, why is not the discretion to the judges sufficient already to deal with this on a case-by-case basis?
Sure, if I can respond. So
Yeah.
first, under 361.5, it's not complete discretion because the presumption's in the other way, right? The presumption is the bypass. And through case law, the presumption is pretty strong. So it's not all things being equal, it's in the court's discretion. It is not. And I have recently had a case where the court said, I'd love to give you services, but I don't think I can. Mm-hmm. And it was a violent felony bypass based on, she drove the car in a burglary years ago. So it's not that the court really does have that discretion under current law.
Why don't we write it so the court has discretion?
And can I take a moment?
Yes.
This is just giving the opportunity for folks that are coming out of prison, coming out of jail. Let's just start that. We send people to jail to rehabilitate. We send people to jail and they pay for their crimes, right? We trust the judge to send them to jail and they go and they spend their time and they pay for their crime. And so when they get out, they should have the same rights as everyone else, unless they abuse that child, right? Or they abuse the child or the mother inside of the home. This is only giving them the opportunity to go through the same system we all would go to if we lost our children. They'd be able to go through with the social worker, go through that 18-month process to see if they're ready to get their kids back, and then trust that the judges that put people in jail, right? Those same judges would have the ability to say if they can have their children or not. We're not placing the children back into anyone's hands. We're just giving them the right to go through the services, to go through the process. And that's what this bill does.
Mm-hmm. I understand. I just think some people should not be around children who commit certain really, really bad crimes, even if the crime wasn't against the child. So I respect your view and where you're coming from, but I do have concerns.
Thank you.
Thank you.
Thank you. Okay, would you like to close, Assemblywoman?
Yes, I respectfully ask for your aye vote.
Okay, we have a motion by Assemblyman Gibson and a second by Assemblyman Jackson. Madam Secretary, please call the roll.
The motion is due pass to the Assembly Appropriations Committee. Lee? Asali?
No.
Asali, no. Calderon?
Aye.
Calderon, aye. Gibson?
Aye.
Gibson, aye. Jackson?
Aye.
Jackson, aye. Mathis? Ortega?
We will leave the roll open, Assemblywoman. Thank you. Okay, Assemblywoman Quirk Silva, whenever you're ready, you can present AB 2450.